About to begin.
We'll be live in 5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, Council, and on behalf of Judge McClarity and Judge Frierson, we welcome the three of you to our oral argument, which we are live streaming to the public to maintain our responsibility to have open courts. We will conduct the hearing in the same fashion as if we were all together in the courtroom. The appellant has 15 minutes to argue and has reserved some for rebuttal. The appellees, two of you, have decided to split your time, and I understand Mr. Hibner is aware of that and will set the clock accordingly. Unless there are any announcements, I will ask Mr. Hibner to call your case.
Michael A. Cress et al. Versus Tennessee State Board of Equalization et al.
All right, we will now hear from the appellant.
Thank you. If the court please, my name is Wayne Kramer with Kramer Racing in the Knoxville Bar, and also with me this morning is Bryce Fitzgerald, one of my law partners. We really appreciate the opportunity to share our thoughts with you this morning about this case. I've been doing this a long time, and I don't believe I have ever seen anything quite like this particular matter. There were two hearings before the Assessment Appeals Commission and two Chancery Court hearings. And while it is the second decision of the Assessment Appeals Commission and the Chancellor's affirmation thereof, which are at issue before this court, the first AAC hearing and decision and the first decision of the Chancellor are certainly relevant. They are a part of the record, and they are very much a part of the story. In any event, much has occurred, and that makes it difficult to describe it all in such a short period of time, but I will do my very best. So these are the basic facts. During all relevant times of this appeal, the taxpayers were the owners of some 32 undeveloped lots. And keep that in mind, undeveloped is very important. Undeveloped lots in a single subdivision located in Knox County. The assessments of those lots by the Knox County assessor were appealed for tax years 2012, 2013, and 2014. It's the valuation of those undeveloped lots and the proper valuation methodology to be used in establishing that value, which were before the Assessment Appeals Commission. 27 of those lots, the Chancellor in his memorandum opinion says 26, and that's not particularly important, but it's just may have been a typographical thing, but 27 of those lots were purchased on or about December 22nd, 2011. December 22nd, 2011. That's 9 days before the initial assessment date of January 1, 2012 under 67-5504. Although broken out slightly differently per lot, when the total purchase price of those 27 lots are extrapolated or is extrapolated over all of the lots, the purchase price was less than $12,000 per lot. One lot of the 32 was purchased in November of 2010 for $20,000, and 4 lots were purchased back in November of 2007 before the Great Recession for $75,000 per lot. So the first hearing. At the first hearing before the AAC, the taxpayers expert, Ben Broom, well-known and respected MAI appraiser in this area, utilizing the discounted cash flow valuation methodology, established the valuation of the lots at $13,438 per lot, an amount very close to the actual purchase price of the vast majority of the lots I just described, only a few days before the initial valuation date of January 1, 2012.
Does that $13,000 average include the lot that was bought for $70,000?
No, it does not. It does not. It includes the lot that was for those lots that were for 4 lots for $75,000 were purchased back in 2007, a number of years before and before the recession. Okay. Despite that expert testimony, the Assessment Appeals Commission, upon motion by the assessor, dismissed the appeal without requiring the assessor to put on even a scintilla of evidence. Upon appeal of that first AAC decision to the Knox County Chancery Court, the chancellor stated, among other things, that the taxpayer produced expert testimony that the fair market value of the lots at issue was $13,438 per lot. The taxpayer's proof was substantial and material in light of the record. And the Assessment Appeals Commission's dismissal of the appeals was made upon unlawful procedure and was an arbitrary and unwarranted exercise of discretion. The case was sent back to the Assessment Appeals Commission for a second hearing. In the second hearing, the taxpayers again relied upon the expert testimony of Ben Broom presented at the first hearing. In contrast to that, the assessor submitted what was either a third, a fourth, or possibly even a fifth set of valuation figures, depending on the lot and the year, and asserted that the lots had a value ranging from as low as $15,000 to a high of $70,000 per lot. In many instances, those values were greater than the assessor had ever claimed before, and even more than the administrative law judge and the Assessment Appeals Commission had affirmed at the first hearing. In reaching all of those different valuation conclusions, the assessor ostensibly argued that he was relying upon the sales comparison approach. But in fact, he actually used 4 different methods of valuing the lots over a period of some 6 years. Those 4 different valuation methods resulted in multiple changes in the assessor's valuations. At the conclusion of the second hearing, the Assessment Appeals Commission, in a split decision, affirmed the assessor's values, with members Osborne and Dooley, both longtime employees of the Tennessee taxing authorities, voting to affirm the assessor's values and valuation methodology, and Dr. Sunderman, the holder of the Morris Fogelman Real Estate Chair of Excellence in the Fogelman College of Business and Economics at the University of Memphis, voting to sustain the taxpayers' values, stating, among other things, and this is really important because this was something that concerned the commission all the way through, and this is what he says: the assessor was using sales from developed subdivisions which would require major adjustments to be made comparable to the subject lots. The inconsistency of the assessor's valuations did not end, however, with the further changing values submitted to the AAC's second hearing. Although the chancellor stated in his memorandum opinion that neither side presented any additional or supplemental evidence at that second hearing, in fact, the assessor did present testimony, all of which further established the inconsistencies, the inappropriateness of the comparables utilized, and otherwise evidenced the flaws of the valuation methodology used by the assessor. In fact, the chancellor recognized many of those flaws, including that a number of the comparables involved sales that came after the assessment dates. 6 of the sales occurred before the market-altering recession of 2008. None of the assessor's comparables are within the subject area subdivision, and the lots at issue, keep this in mind, while undeveloped, the assessor used sales from developed subdivisions with improved lots for his comparables. In short, the taxpayers established a value for each of the lots, utilizing the discounted cash flow method through the expert testimony of Ben Broom, while in contrast, the assessor literally came to hundreds of different valuation conclusions using multiple different methods of valuation. Without considering the additional evidence, using a wrong standard of judicial review, and failing to properly utilize the right methodology valuation, the chancellor affirmed the second decision. So now the law. Those are the facts.
Excuse me for interrupting, counsel. A question with regard to the additional or supplemental evidence. There was additional evidence during the second hearing before the commission. Was there additional evidence or supplemental evidence before the trial court upon its review?
Yes, there was. I think you'll find some additional 46 pages of transcript in the record that took place before the chancellor. That's correct.
So that was additional evidence which was not considered by the commission during the second hearing?
That's correct.
Thank you.
Keep in mind, Your Honors, this is not an appeal from a typical administrative agency. This is an appeal from a decision of the Tennessee State Board of Equalization pursuant to 67-5-1511B. They are different. The judicial standard of review is different, and that is significant. The chancellor is clear when you look at his opinion. He felt completely constrained. He could do nothing. He said he couldn't substitute his judgment. Essentially, he said he had no choice but to affirm the decision of the Assessment Appeals Commission. That's not correct. The state board, speaking through the Attorney General, acknowledges that the chancellor utilized an inappropriate standard of review. This is what he says in his brief relative to 1511B. The trial court should exercise its independent judgment and is unrestricted by deference to the board. He goes on to say, a trial court hearing such evidence must reach its own conclusions, not defer to that of the board. Not only did the chancellor fail to consider the facts, not only did the chancellor fail to use the appropriate judicial standard of review, but ultimately he failed to use the appropriate methodology for valuing these lots, as did the Assessment Appeals Commission. Keep in mind, these are undeveloped lots. So the chancellor himself made that finding. There's no dispute about that. They are undeveloped lots in one subdivision. So how do you value them? Well, the statute's clear. The statute says you determine it by fair market value. Willing buyer, willing seller concept. This court's very familiar with that, I have no doubt. So the question is, how do you determine fair market value in this context? Well, then go to 67-5-602. Among other things, it says the assessor shall be guided by and follow the instructions of the appropriate assessment manuals issued by the Division of Property Assessments. Okay, so now let's go further. What do the other authorities say, and what does the manual of the Division of Property Assessments say? What they say is, at a federal level, the FDIC guidelines say the discounted cash flow analysis is the way to do it. The appraisal of real estate, indeed often referred to as the Bible for assessors, says discounted cash flow method is the way you do it. And last but not least, in fact, maybe most importantly, the Tennessee Division of Property Assessments in its own assessment manual specifically acknowledges and affirms that the discounted cash flow method, albeit they refer to it as the land development approach, but it's the same thing. What they say is that's the appropriate method to use in this type of situation. And they particularly acknowledge, and keep this in mind, they particularly acknowledge that that's when you use that valuation method when similar land sales are not available. That's true here. The fair market value of the lots at issue must be determined utilizing the discounted cash flow method of valuation. There is nothing in any of the briefs submitted by either the assessor or the state board that really disputes that. So if the court please, when the facts and the law are reviewed, everything points to the reality that something here is seriously wrong. What is wrong? One, the failure to consider the evidence was wrong. Two, the failure to use the proper judicial standard of review is wrong. And three, the failure to use the required valuation methodology wrong. 3 strikes, Your Honor. And when you consider that, the only result is the decision of the chancellor must be reversed and the values of the lots asserted by the taxpayers should be affirmed. Thank you.
Thank you, Mr. Kramer. We'll now hear from the appellees.
Good morning, and may it please the court. I'm Mitch Porcello from the Tennessee Attorney General's Office on behalf of the State Board of Equalization and the Assessment Appeals Commission, and I'm going to take a short 5 minutes to address the proper standard of review. In the proceedings below, the Chancery Court misstated the standard of review for state board cases. The proper standard of review is de novo, not the deferential substantial and material evidence standard under the UAPA. Nevertheless, as Mr. Starkey will explain in his argument, the assessor's valuation based on comparable sales should be upheld under any standard. Judicial review of a state board decisions is governed by TCA 67-5-1511B, which provides that review shall consist of a new hearing in the Chancery Court based upon the administrative record and any additional or supplemental evidence which either party wishes to adduce relevant to any issue.
Excuse me, counsel, for interrupting. If the trial court incorporated the wrong standard of review, what does your client assert is the proper remedy on appeal?
Our assertion on appeal is the state board's interest is to get the standard of review correct, and it should be de novo. Here, applying any standard, because there is no preferred method, there is no legally required method of valuation, it was appropriate for the assessor to use comparable sales, and therefore under any standard of review, and Mr. Sturkey will get into this more during his argument, under any standard of review, the decision of the assessor to value the property using the comparable sales approach should be upheld. But the court did misstate the standard of review in that 67-5-1511B controls, not the UAPA standard. The language in 1511B is taken directly from a Supreme Court case, the 1984 case of Fry, and that is the exact language the court used to describe de novo judicial review of an agency decision. In 1991, this court in Richardson considered the 1988 version of this statute, which was different in that it was different in language, not in the standard of review. It provided that the state board decisions judicial review shall be a de novo appeal to the Chancery Court of Davidson County or the county where the disputed assessment is made. The 1988 statute provided for de novo judicial review because it also provided that taxpayers and assessors could be represented in the administrative proceedings below by non-attorneys. And the concern was that a record created by non-attorneys could prejudice the parties on appeal. So the de novo standard was adopted.
In this case, did the trial court consider additional or supplemental evidence during its review?
The trial court did, yes. I believe the assessor's valuation expert was put on. The record below was put in, and I believe there were 5 exhibits presented to the trial court. So there was additional evidence considered. So the Richardson court recognized that there was a differing standard of review between the UAPA and 1511B, and then quoted the Fry decision as generally understood from common usage. The term de novo means a new hearing in the Chancery Court based upon the administrative record and any additional or supplemental evidence which either party wishes to adduce relevant to any issue. After that decision, the Richardson court decided as the later act 1511B controlled, so de novo review was the standard. After that decision, the statute was changed to adopt, instead of calling it de novo review, it adopted the exact definition of de novo review from the Fry case and the Richardson case. And that means no deference to the administrative agency. The trial court must consider the facts and determine the law as if no prior determination had been made. The trial court must exercise its independent judgment and is unrestricted by any deference. This is de novo review, and that's what 1511B, which is the standard for state board cases, requires.
Are you saying that we should remand the case for the trial court to conduct the review based upon the de novo standard, or are you encouraging that we marshal on and do our own independent de novo review?
Our position is that under any standard, the valuation should be upheld. The assessor used the comparable sales method, and Tennessee law does not require any specific method of valuation. The manual of the property assessor's manual prefers comparable sales. So
I guess the
issue
short
here-
answer is you want us to marshal on.
Yes, the short answer is that the determination of whether to uphold the assessor's valuation or not is based on the selection of the appraisal methodology. And since the comparable sales methodology is the preferred methodology, it was appropriate for the assessor to use that methodology.
All right, thank you. We'll hear from the other.
Thank you.
Let me ask one other thing.
Yes, sir.
Dan, you're not saying that we should marshal on and do an appropriate review. You're saying that the review that the chancellor made, even though he used the wrong standard of review, the same result would have resulted anyway. So you're saying that we should affirm his review, not marshal on
Yes.
and review it.
I apologize if I was confusing about that. Yes, the decision should be affirmed because the misstatement of the standard of review should not affect the outcome, given that the methodology used by the assessor is an appropriate methodology. And it's not that there are facts in dispute so much as the dispute of which methodology to use, which we believe is can be affirmed by this court without remand.
All right, thank you.
Thank you.
Mr.
Good
Sturgeon.
morning. Good morning. May it please the court, I'm Charlie Sturkey in the Knoxville Bar representing Knox County and John Whitehead. And to begin with, I'd like to point out one issue in particular. Throughout their brief, the taxpayers have referred consistently to the fact that the assessor's work was quote unquote fraught with fallacies. And as noted at page 1 of our brief, the actual citation or actual quotation from the chancellor's opinion, which is on page 7, is the taxpayers further argue that the assessor's most recent attempt to value the property is fraught with fallacies. So it's our argument that that's not a finding that the chancellor made. He was characterizing the repeated argument of the taxpayers. And he does go on, the chancellor does go on page 7 of his opinion to set out several things that they say were fallacies on our part. But then importantly, at the very bottom of that page 7 of his opinion, the chancellor goes on to say, on the other hand, the errors argued by the taxpayers are apparently without effect. And he points out that the highest retail market value from the assessor was less than the base retail market value used by the taxpayer's appraiser. In effect, even if the efforts of the appraiser were all over the board, as the taxpayers argue, and different methods were used over time, the bottom line is the base value determined by the taxpayer's appraiser was actually higher than the top dollar from the assessor's office. So to point that out, number one, which brings me then to the question that's already been dealt with. What are we trying to find out? We're trying to find out the value of these properties, the immediate value of these properties, without consideration of speculative values. And that's one of the arguments that we have made throughout this several hearings we've had now, is that with all due respect to Mr. Broom, and I mean that seriously, he has a lot of speculative issues, a lot of speculative aspects to his opinion, which render his use of his methodology in this case inappropriate and leave us with using the sales comparison approach used by the assessor's office. And I would point out briefly, and this is from the second hearing before the Appeals Commission. So the chancellor did have this before him, had his second hearing, and did review it. So this is not in that category of, well, I didn't review stuff that I actually did. He understands, and it's clear that he did understand he was reviewing this portion of the testimony. And the actual testimony is in volume 9 of the appellate record. But one of the things Mr. Mathis testified to at the second commission hearing, which was in 2017, dealt with the absorption period. He referred to the exhibit 3 to that hearing, which is in the record here before your honors in volume 2, pages 175 through 77, and talked about the fact that the absorption period, the number of properties that would be sold per year, according to the 9-year absorption period set out by Mr. Broom, well, the first 2 years, there are going to be 2 lots sold each year. But he pointed out that as Mr. Broom had testified at the first commission hearing, that didn't happen. The first year, no lots were sold. The second year, 4
Counsel,
lots.
excuse me for interrupting, and I certainly do not intend to derail your argument, but I have a question concerning the standard of review. If the trial court incorporated the wrong standard of review, does this case need to be remanded for the trial court to use and incorporate the proper standard of review?
Your Honor, I've thought about that, and with all due respect to Mr. Porcello, I think it does need to be remanded. And I know this has been going on for 7 years. At least I've been involved in it 7 years, and so I'm sure we'd all like to come to a conclusion. But respectfully, unless the court, this panel decides that, despite that, if your honors look at it, but then again, you're taking the job away from the chancellor. And so if it's determined that the proper standard of review is different than what he used, I think respectfully, it needs to go back. Addressing that issue, while I may, on the issue of what
So
is.
you do not go along with the proposition that even though the wrong standard of review was used, the same outcome would be even if the right one was used?
Well, no, actually, I've made that argument in my brief, that no matter what standard is used, if you look at the argument, if you look at the information, you come to the same conclusion. So, but I can certainly see from your perspective, respectfully, let the chancellor have a chance to review it using the proper standard of review, but I'm not sure he didn't use the proper standard of review. Again, with respect to co-counsel, the Willamette case, which I know is part of my problem is, and I confess confusion, you have different appellate cases, as you all well know, saying different things, and nobody's ever overruled any of them that I'm aware of. You got the Willamette case, and I have a copy from the actual, hard copy books, like in the old days. At the bottom, it says the Supreme Court recommended that the Court of Appeals opinion be published, even though they denied permission to appeal. So I don't know what strength that gives that case, but that's what the hard copy in the book says. And you look at the Dooley case, and that says at one point that the petitioners sought relief under 67-5-1511, but 2 or 3 pages over, the court itself says that the proper standard of review is under the Administrative Procedures Act, 4-5-322H. So I'm not 100% sure that the chancellor didn't use the right standard of review. And of course, that's part of the problem we have before us, that we have these various cases, and the Willamette and Dooley cases were subsequent to the Richardson case. So, and I'm getting off, that's probably more than you want to hear from me on that subject.
Counsel, I have a question that I've asked before with regard to the additional evidence. As I understand, the trial court and its memorandum of opinion indicates that although neither side introduced any additional or supplemental evidence at the hearing before this court, the APA precludes the court from substituting its judgment and goes on. Was there additional evidence or supplemental evidence which was introduced during the hearing before the trial court? And if so, what impact does that have with regard to the trial court's finding that there was none introduced by any of the parties?
Yes, Your Honor. The assessor's office put on Mr. Mathis, who gave additional testimony, additional to what he testified to at the second AAC hearing. And so, which of course we say helps support our position. So if indeed the chancellor did not consider it, of course, our first argument is if you just look at the evidence before the AAC that Mr. Mathis put on, that's sufficient to support the chancellor's decision anyway. But yes, Your Honor, there was evidence that was, and as I think Mr. Kramer referred to the fact there's 40 some odd pages, I guess, I didn't count, but of testimony. that Mr. Mathis gave to the chancellor at the second hearing.
Thank you.
Yes, sir. So and I've set this out in my brief, and so I won't go into as much detail as I might have. We say that if you look at our brief at pages 3 through 8, 4 through 8, we set out the sections of the testimony, refer to the sections of testimony where Mr. Mathis points out the speculation in Mr. Broom's testimony before the AAC, dealing with not only his actual report, but how in certain cases properties which he valued at $13,000 something were sold for many times that. And an argument was made, well, those sales were after the January 1 date for each tax year. Our response was yes, but for the narrow purpose of the reasonableness or speculative nature of what Mr. Broom did, for that limited purpose, these later sales are indeed relevant and emphasize and underscore the speculative nature of Mr. Broom's approach. And so if you take that in addition to and Mr. Mathis explains what he went through with these different approaches, why he took different approaches. He got more information as time went on, and so he refined his numbers. There was changes to the properties that required numbers to be refined. I'm running out of time. Respectfully, we would ask that the opinion of the chancellor be affirmed. Thank you.
Thank you. We'll hear a rebuttal from Mr. Kramer or Mr. Kramer's partner.
Thank you, Your Honor. There's a lot of things I'd like to say, but I'll try to get it as much as I can in the next 2 minutes. First, as it relates to the chancellor and the notion of being fraught with fallacies, I don't believe it is possible to read that opinion without coming to the conclusion that he agrees that their proof was fraught with fallacies. Indeed, the Assessment Appeals Commission itself over and over was concerned about the comparables and where they were located, some of them 14 miles away from the subdivision at issue and so forth. So there is no doubt in my mind that it was fraught with fallacies. Number two, the notion that, and I think this has already been clarified, but there was additional proof put on before the chancellor. He says there was not. And there was significant additional proof, which again reaffirmed the problems with the assessor's proof. The standard of review, it was the wrong standard of review. If you read that opinion, and nobody knows for sure, but if you read that opinion, I don't think there's much doubt that the chancellor would have come to a different conclusion if he thought he could. He thought he was essentially completely bound by the AAC's decision. And he was not. Last and not least, if you look at the values that they have placed on this property, it is unbelievable. Hundreds of different values. My brother, Mr. Porcello, says the preferred, if you will, methodology is a sales comparison approach. No, that's not it. The law and the assessor's own manuals say it's the discounted cash flow analysis. And last but not least, we believe that under these facts and the applicable law, and I say this with all seriousness, the legitimacy of a taxpayer's right to appeal under 1511, 67.5, 1511B is at stake. And I believe that with every being in my fiber. Thank you, Your Honor.
All right. Thank you, Mr. Kramer, and all three counsel for your arguments. You've given us a lot to consider. We will take the matter under advisement. Mr. Hibner.
This honorable court is now in recess until 1:30 p.m.
Thank you, and counsel, you're free to exit the meeting.
Thank you.
Judge Clement, I won't be with you this afternoon, so.
Oh, we're going to miss you. I tell you what, we are going